morning, everyone out there. Happy holidays to you all. We have many clients and friends on the line. It's great to have all of you, and we have some new guests as well, and it's great to have you here as well. For our new guests, let me just tell you briefly about Schoeneck King. We are a full-service law firm counseling individuals, companies, not-for-profits, public sector entities in a wide spectrum of areas. We currently have 230 employees who are working in 11 offices. Today we're going to be talking about the National Labor Relations Act. Our Labor and Employment Department here at Bonn actually began with passage of the NLRA in 1935. Today we have one of the largest labor and employment practice groups in the country, and certainly in New York, with 63 lawyers practicing solely in this area and representing management exclusively. Well, these are certainly some challenging times for our clients in the labor management, relations, and human resources area with a veritable whirlwind of changes which have taken place, which are currently taking place, and which are likely to take place in the future here. And no place typifies those changes better than the National Labor Relations Board. Today we're going to talk about what I view as an incredible decision from the National Labor Relations Board that addresses the rights of private sector employees to use their employers' email systems. In terms of our agenda today, I want to talk briefly about how we got to where we are today with the National Labor Relations Board. I'd like to talk about the board's decision and what it means for employers, and then talk about what additional issues should be taken into consideration and what steps should be taken right now to address this new decision. I do anticipate there being some time to answer some questions. We do have a very large group here, which is great. We're happy to have, but it will make it impossible for us to answer every question. But please fire away, and again, we'll do our best at the end of the presentation to address those. So to start, we have to go back to 1935 and establishment of the National Labor Relations Act. It was a very different workplace, as I'm sure we can all appreciate at that time. There were virtually no protections in place for workers or rules governing the workplace, and the National Labor Relations Act was part of President Roosevelt's New Deal legislation and was passed to ostensibly fill that void. A primary effect of the legislation was the proliferation of union formation and organizing and collective bargaining in the workplace. And just some 20 years after enactment of the Act, more than 1 out of every 3 workers in our country were represented by a union. Today we see a vastly different scenario. Union membership has dropped precipitously over the years. Now 14 out of every 15 workers here in our country are union-free. And moreover, the current union activity and gains that are out there have typically been concentrated in the public sector and in the healthcare arena. A question comes up, why? Why is that the case? Well, again, it's a very different workplace now than it was back in 1935. We now have a panoply of local, state, and federal laws that are designed to protect workers and regulate the workplace. We have thoughtful employers with good values who are mindful of these requirements, who treat employees respectfully and fairly, and who provide competitive compensation and benefits. And so, as I analyze the dynamics here, it's hard to argue with the notion that employees just typically aren't as interested in and see value in union formation as once upon a time. And so the labor movement, and in turn the National Labor Relations Board, is fighting to stay relevant in today's workplace. And in the last 2 or 3 years, we have seen unprecedented activity and change at the board. Former Chairwoman Wilma Liebman, who is a Democratic appointee and longtime member of the board, called the board the Rip Van Winkle of federal agencies, and she chastised her colleagues that they needed to wake up and get with the times. What we've also seen as part of this fight for relevancy is the board increasingly focused on non-unionized workforces. And we'll explain how that dynamic is relevant to today's topic as well. And so with President Obama came a new era of change. That was one of his slogans for the campaign. And one of those changes has been the appointment of a zealously pro-union NLRB majority at the board. Now, the NLRB itself is a political body. It's controlled by presidential appointees, and the decisions from the board have typically swung on a pendulum over the years, depending on who is in office, between management on the one side and labor on the other. Now, we've had a board for many years controlled by a majority of President Obama appointees who, make no mistake, want to do everything they can to change the trends of late and increase union membership. And they're not afraid to take drastic action. I'd say trying to break the pendulum that has historically swung rather than just move it. We've seen numerous decisions over the past 2 years overturning decades-old precedents at the board, precedents that had survived changes in administrations and majority status of the board. Again, we've seen the focus on non-unionized employees in emerging areas, such as social media and their activity on social media outlets. And just within the last few days, as a matter of fact, we've seen 3 very significant developments at the board. The first dealing with union organizing and elections, and we did a webinar on that yesterday, as a matter of fact, which I believe many of you attended. Those changes are designed to make union organizing easier and make it more challenging for employers to oppose those campaigns. We've seen a long-standing precedent from the board deferring to grievance and arbitration processes and decisions that parties have agreed upon rather than pursuing litigation at the board. Those standards have now been changed. And of course, we're here to talk today about the fact that the NLRB has changed course on the rights of employees to access email. Before we delve into that, let's talk just a little bit about 2 pieces of the NLRA which are at the heart of this issue. The first is Section 7. Section 7 is really the heart of the NLRA, and what it does is, among other things, guarantees employees the right to form, join, or assist unions, and to engage in other concerted activities for mutual aid or protection. In turn, Section 8A1, which deals with unfair labor practices, makes it an unfair labor practice for employers to interfere with, restrain, or coerce employees when they are exercising the rights that are guaranteed by Section 7. And again, these rights and these statutes apply equally in the private sector with non-unionized workforces and with unionized workforces. So the first time the NLRB addressed the issue of employee access to email was in 2007, at that time with a majority consisting of President Bush appointees. There was a policy that prohibited employees from using the email system for non-job related solicitations. The board found that that prohibition was lawful. In doing so, they noted that the employer's email system was its property, and it was property that it had purchased for use in operating its business. And the fundamental holding in that case, registered guard, was that employees do not have a statutory right to use their employer's email system for Section 7 purposes. In analyzing the issue, the majority focused on prior cases dealing with other types of employer equipment, property, and outlets. There were cases dealing with access to television, to bulletin boards, to copy machines, to telephones, to PA systems, even to scrap paper. In those cases, the board found that there was no inherent Section 7 rights for employees to use those resources because they were company property. Now, there was a vigorous dissent that Chairwoman, then member Liebman, filed in the registered guard case, which essentially said, hey, wake up, folks. Email is different than other types of property. It should be treated differently by the board, and employees should presumptively have access to that resource for Section 7 purposes. Essentially, some dislocation of the employer's property right, in that case, may be necessary to safeguard the employee's rights to exercise Section 7 activity. In citing to an old case, Republic Aviation, circa 1945, Liebman referenced that decision to support her position. Nonetheless, what we had here was the majority establishing a clear, bright line for employers and employees to follow, and it was easy to understand. And so some 7 years later, the board has now controlled by a majority of strongly pro-union members appointed by President Obama, decided to revisit this issue in a case involving Purple Communications. Purple Communications was a business that provided sign language interpretation services, and employees would use their email for this purpose and for other work-related purposes. Before you see Purple Communications policy, which was at the heart of this case, and I've highlighted in red there the key provisions that are relevant here, but you will see that the policy restricted the employees' use of cell phones, email, etc., for business purposes only. And this policy was perfectly lawful as written on its face under registered guard. Remember, under that case, employees had no Section 7 rights to use their employer's email system. With the Purple Communications case, however, the union in that case and the National Labor Relations Board took the position that the prohibition was unlawful, that email is the primary means of workplace discourse, that prohibiting personal use of email substantially interfered with Section 7 activity. In other words, it violated Section 8A1. And that registered guard was wrongly decided, and that in weighing the employer's interest in its property rights over the employee's rights to engage in Section 7 activity by using that property, the board had erred. As the case worked its way through the system, the administrative law judge who heard the dispute at hearing found that the policy was not unlawful. It dismissed the ULP, and in doing so said, listen, I'm bound to follow the board's decision and register guard. That decision was then appealed to the NLRB, and it was teed up for their adjudication. And so the board turned 180 degrees and overruled registered guard. We have on this slide boiled down the essential holdings for your reference, and I'd say this is probably the key slide in the entire presentation for you to consider. I want to go through it quickly here, and then we will drill down into the particular terms and what they mean in practice for you. But what the decision did is establish a presumption that employees who already access their employer's email system for their work also have a right to use the email system to engage in Section 7 protected communications on non-working time. That presumption can be rebutted, and restrictions can be imposed by the employer so long that there are special circumstances existing that are necessary to maintain production or discipline. We'll again, talk about these terms and what they mean. So again, we have a presumption of access that the board has established for employees, which is rebuttable provided the employer makes a sufficient showing of special circumstances. All right, so what's the basis for the board's change in course here? I can tell you in an attempt to justify its actions in changing course, the board majority spends a considerable amount of time in the decision explaining how prevalent email use is at work, It's really not essential for us to go through the justification in detail, but essentially what they're saying is that email is the new gathering place for employees at work. It's no longer just a water cooler. And just as other restrictions on employees accessing and engaging in protected activity in certain physical spaces at work have been deemed to interfere with the exercise of Section 7 rights, so too have business use only email policies, thus necessitating that access to this resource be afforded to employees. And where, according to the majority, where there is a sufficient interference on the part of the employer in establishing or limiting access, their property rights to do so must yield to the rights of employees to exercise their Section 7 rights. And again, it's essentially a balancing act that the board has undertaken here, and they've said we're going to balance it in favor of granting employees access. And they've, in the process and in their decision, marginalized the property rights of employees to control the email system that, employers to control the email system that they've purchased and supported. The board has also taken the position that, well, essentially, it's not going to have any impact on usage of the system, or it'll have virtually no impact or minimal impact. So there's really no harm to the property interest to begin with. So let's drill down into the actual meaning of the rule. Again, it covers employees with rightful access to their employer's email system in the course of their work. The term employees is essential for us to keep in mind here. And not everyone, not all employees are covered by the National Labor Relations Act. In this circumstance, employees would not include supervisors or independent contractors. It would not include public sector workers. And there's other types of exempt employees who aren't covered under the Act. It does, however, as I mentioned, include employees in both non-unionized and unionized work settings. So a common misconception that's out there is, well, listen, I don't have a union at my place. I don't need to worry about this. That's not correct. You do need to be mindful of this. Also, the new rule applies to emails with rightful access to their employer's email system. So the rule does not require that employers grant email access to employees who are covered who do not already have such access. And the rule makes that point, the decision from the board makes that point very clear. As I mentioned, the rule provides a presumptive right for employees to use, covered employees to use the email system to engage in Section 7 protected communications on non-working time. And we talked before about what Section 7 involves. It's the right to engage in protected activity for mutual aid and protection or for union organizing purposes. You might, however, be shocked to learn what the current board at least considers to be protected communication. Again, keep in mind their overarching goal here and their point of view with respect to unionism. I'll mention a couple cases to try to illustrate where the line is being drawn right now in terms of protected communications. There was a notable case involving a retail establishment where a subordinate employee had chastised his assistant manager in front of customers. Specifically, he had asked the assistant manager for some assistance. The assistant manager could not immediately come and help. And once the assistant manager did, the subordinate employee said, well, it was about blank time you did, again, in front of employees. And also told, eventually, the assistant manager that he could go blank himself in front of, again, customers. That employee was terminated for insubordination and for threatening the manager. The board, however, took the position that that was protected communication. It focused on terms and conditions of employment, was for mutual aid and protection, and therefore the termination was deemed unlawful under the Another case involved an employee repeatedly calling a supervisor disparaging names, using the F word, and threatening the supervisor that he would, quote, regret it if the employee was terminated. Again, there, the board took the position that was a protected communication. Finally, another example in the Friesenus case, there was admittedly vulgar, offensive, and threatening statements that were made in a pro-union newsletter that was left in an employee break room, multiple letters as a matter of fact, that referred to employees in a highly degrading and vulgar manner. Frankly, I'm not even comfortable referring to what the term is here, and also telling the target employees that they would rest in peace. Again, a clear threat there in my mind. Nonetheless, that was deemed to be a protected communication on the board. So again, keep in mind, at least as the board stands right now, they're pretty lenient in terms of what they're going to deem to be protected communications under the Act. So we have the presumption of access for covered employees. And now the board has also concurrently created a mechanism which, in theory, employers can use to rebut the presumption of the right to access and then impose restrictions on such access. Of course, that begs the question of, well, what are these special circumstances necessary to maintain production and discipline? And the board here has pointed to a case I mentioned earlier, Republic Aviation, which is a World War II era case that dealt with solicitation in the workplace. It's not a case or standard that is going to be easy to apply to email. And frankly, just as an aside, it's a bit ironic that the board, in trying to get with the times here and modernize its view on use of email, is now using a World War II era case to set the standard for employers to follow. Unfortunately, the decision itself provides very, very little guidance in terms of what these special circumstances might be. I'll quote a few areas for you that are helpful. They say employers can apply uniform and consistently enforced controls. Again, I think the key there is uniform and consistently enforced over their email systems, which are necessary to maintain production or discipline. What the board says, though, is essentially there needs to be an actual demonstrable problem. A theoretical problem isn't going to be enough to justify you imposing a restriction on this presumptive right. And furthermore, the restriction that you impose must actually have a nexus with the problem and must be closely tailored as minimally as possible to address the problem. Moreover, the problem that you may point to as the basis for imposing the restriction can't be caused by the other type of permissible use of the email system. So there's a lot of different ways to read that, and we'll have to see how that gets interpreted. But one thing that jumps out to me is if you're going to try to use, let's say, volume and concerns about volume as the basis for imposing a restriction, that may not be justifiable from the board's perspective because, well, hey, the legitimate use that our employees are afforded under their policy for work purposes also contributes to a volume issue. There is a little bit of guidance in the decision that talks about it perhaps being possible for employers to prohibit large attachments or audiovisual segments if the employer can demonstrate that they would interfere with the email system's efficient functioning. Again, that might be easier said than done, and I think the employer who tries to rely on that as a basis needs to be prepared to demonstrate that indeed there was an underlying problem. Well, this raises, in my mind, a number of potential issues that are ancillary to the actual holding of the case. I'm sure many of you with email systems and communication use policies have monitoring that takes place, and for very good reason. We need to make sure our systems are used appropriately, are not used to harass employees or put the employer at risk for liability. And so there is a legitimate need to monitor email usage. That need now somewhat conflicts with a potential risk of unlawful surveillance under the NLRA. There it's unlawful to surveil employees who are engaged in protected activity if that is, and I'm oversimplifying here, but coercive or would effectively chill the exercise of their rights. These two issues seem to conflict for one another, and the board, anticipating this, has addressed it. What they said is, hey, it's going to be fine for you employers to continue monitoring your email usage so long as you do nothing out of the ordinary. They don't give a whole lot of explanation as what out of the ordinary means, but they do give an example of saying, well, it would be out of the ordinary if you increased your monitoring efforts during an organizational campaign or focused your monitoring efforts on protected conduct or union activists. That's a pretty clear case there that I think would be clear to most practitioners in this area that would not be permissible. What they've also said is ordinarily it's going to be okay for you to advise employees if they have no expectation of privacy and use of the employer's email system. And that's a common feature that we see in many policies, and frankly we encourage you to have in there just to make that point perfectly clear. Another issue is, well, what if you allow employees to currently use email for non-work related purposes during working time? I think this is an open issue that is not squarely addressed. I mean, clearly there would be an issue if you're going to allow personal use during working time for certain things, but then prohibit employees from engaging in Section 7 activity. Beyond that, I can foresee other issues potentially arising too, where you've got a use already in place for non-work purposes during working time. And then what about other forms of electronic communication? The board in the decision made clear that its holding only applies to email, but when you read through the decision, it can just as easily apply to rationale and access issues relating to other forms of electronic communication. And the board even said in the decision that things like texting or IMing using employer resources may be subject to the same analysis. Now, they did not hold that in the case, but it's something for us certainly to keep in mind and consider. Some other potential issues that are out there in our mind, Section 882 of the National Labor Relations Act makes it unlawful for employers to contribute financial or other support to a union. The board historically found that employers can violate this provision by providing things as minimal as pencils or paper or telephones, calculator for employees to use during paid time. You're unfairly supporting the union in those situations. The majority really addresses this squarely and says, well, look, how could this possibly be an issue under 882 if we're saying an employer can lawfully allow this type of access? Moreover, the Labor Management Relations Act makes it unlawful with potential criminal liability for an employer to pay, land, or deliver anything of value either to a labor organization or an officer or employee thereof, and to provide means of support to try to influence any employees in the exercise of their Section 7 rights. Again, a bit of an oversimplification there, but I think you understand the point. There is this prohibition on supporting financially the entities referenced. And the reality is computer systems and email infrastructure cost significant amounts of money to operate and maintain and purchase and staff accordingly. And so conceivably, the access that employees are going to receive could be deemed a thing of value for purposes of the Labor Management Relations Act. Once again here, the majority dismisses this concern outright and deems any such concerns to be far-fetched. I guess that's easy for them to say. Finally, there is, I think, a possible constitutional issue here, and one of the board members who dissented on the opinion noted this and spent a good amount of time explaining it, and essentially the crux is making someone pay, in this case employers, to sponsor speech, in this case paying for their email system, that person opposes is an affront to the Constitution. So this is, I think, a legitimate issue, and one that we may see play out further on this case. So that leads us to what should be done right now. I think first and foremost, it's a time to take a look at your policies, and not only your policies, but your practices that relate to email usage. If you do have general bans on non-business use or personal use, those consistent with the new opinion from the board should be eliminated. It's a good time to make sure you've got appropriate key terms in your policy. Do you advise employees that they may be subject, and their email use may be subject to monitoring, and any attachments and other items that are conveyed will be subject to monitoring? Does your policy include the disclaimer making clear that employees should have no right or expectation of privacy in their email use? And what about limitations on personal use during working time? How are you going to address that issue? To what extent do you want to impose such limitations? I think that's one that's going to vary depending on your workforce and other issues, but certainly something that you need to think about at this point. Of course, we need to be mindful of other potential National Labor Relations Act issues, that even if you have a policy that on its face is facially valid, discriminatory enforcement of that policy, let's say focusing only on Section 7 protected activity, will raise issues under the National Labor Relations Act. Other restrictions dealing with Section 881, we have to make sure that if we have terms and conditions of use in terms of what can be said or cannot be said via email or other company resources, that those recognize the rights of employees to engage in protected activity under Section 7, and that we don't want our policy to be construed as overly broad and potentially chilling the exercise of those rights. And additionally, if you should have a union in place at your workforce and you're going to be making changes to policies or practices, you need to consider whether or not there's a duty to bargain before implementing those. I think you also need to make sure to review how your policies and procedures have actually been applied in reality. How has this worked to this point? I do think you want to evaluate how have you been monitoring email usage to this point, and does it make sense now to make any changes to that policy? And that, to a certain extent, is going to be driven by what kind of restrictions you're ultimately going to decide to put in place governing email usage, and then to decide what kind of monitoring are we going to do to make sure that our system is being used properly and in a manner that's consistent with our policy. And of course, let's stay apprised of further developments in this area. Here, I think we're likely to see more developments I think stay tuned on this. And finally, I think you need to consider, are there positions in your business, your organization, where the restrictions on the use of email for non-work purposes is necessary to maintain production or discipline? I think that's got to be part of the decision-making right now. And more importantly, or equally important, will be, well, how am I going to meet my burden to establish that those restrictions are truly necessary? because it's going to be up to you, the employer, to do that. So what else should we do right now? I think we want to consider now, what are we going to do when an issue arises involving employee email use? First and foremost, let's think about how is this likely going to come up at work. And that will depend on your workforce and how things are structured. It may be that you as an HR professional or other person with supervisor responsibilities are forwarded an email that is of concern to another employee. They may bring a printout of an email to you for you to consider. And I think you need to do a number of things at that point, one of which is to be ready to assess, well, is the email sending and the content of that message activity that's protected under the National Labor Relations Act? So does it relate to union activity, or is it discussing terms and conditions of employment with other coworkers of the like? If there's certain things in that message that are inappropriate, is the conduct so outrageous that it might lose the protection of the Act? And then we need to make a distinction between an individual gripe, which isn't protected under the National Labor Relations Act, and then discussing issues that are concerted in nature and involve concerns of a collective part, right? More than one person that potentially involves. And here's the thing on what's protected and what's not protected. That line's gray. It's not a bright line right now. It certainly isn't with respect to the current National Labor Relations Board, and it's in a state of flux. Keep in mind, again, the board's pro-union, pro-employee point of view right now, and we would recommend when you've got this issue and it comes up, there is value in seeking counsel on this. I think you also want to train supervisors on these requirements and your policies. And if an issue like this comes up where there is an email communication, we need to recognize that this is an issue that's in the board sites right now, and we want a red flag to go up on our supervisors' minds so that they can bring this to the appropriate folks' attention if necessary, or otherwise be prepared to handle the issue themselves. And finally, you need to be prepared how to handle the situation and what to do where, let's say an employee sends out a protected communication to a mass group within your organization. What are we going to do in response to that? How do we need to address that? And I think, again, that's something that's going to vary on a case-by-case basis, but it's something to consider here as we get ready. Well, Kathy, I saved just a couple minutes for some questions, and let me try to address a couple here. I have one here that asks, does this new rule apply to the public sector? No, it doesn't. The National Labor Relations Act covers employees in the private sector. Here in New York, we have the Taylor Law and PERB that focuses on the public sector and public sector employers. The decision of the National Labor Relations Board is not binding on PERB here in New York for our municipal employers, and there are different rules that apply. Now, conceivably, a board like PERB could take into consideration as guidance, non-binding guidance, the decision of the National Labor Relations Board, and they've done this before on occasion. So keep that in mind, I suppose. Well, what if we keep the ban on personal use just as a deterrent, but we don't intend to actually enforce it? Well, I can tell you that can still be a problem. Having an overly broad policy like this would still constitute a violation under 8A1 of the Act, and moreover, that broad policy, even if you're not going to be disciplining anyone under that policy, can still raise a number of issues. There have been prior cases where employers have prevailed in a union election, and that election result has been overturned following objections that were made to overly broad policies that were deemed to have influenced the election in an unlawful way. So again, the policy as written can have ramifications simply beyond disciplinary matters. Do you think there will be a successful appeal of the decision? Well, I do think that some form of appeal is very likely on this case. It's garnered a lot of attention. I think it will get more attention. In my analysis, the board majority here has gone out of its way to try and build its case so that this holding will survive an appeal. Whether they'll be successful in this remains to be seen. I think there are some grounds here for them for an appeal to be made, dealing with the constitutionality of this under the First Amendment, that there is an unreasonable infringement on property rights here, and that there's a lack of evidence on the board's part showing that if these bans on personal use have truly interfered with the exercise of Section 7 rights.